conversation with Professor William Schabas. I want to remind the online audience that you can ask questions. You just gotta pop them in the chat there. I want to acknowledge our main sponsor, the Rosenbluth Family Charitable Foundation, and thank the Zorian Institute again for this session, for the international jurists that you brought in. So I will reintroduce Professor Schabas for those who are just joining. William A. Schabas is a professor at Middlesex University in London, emeritus professor at Leiden and the University of Galway, distinguished visiting faculty at the Paris School of International Affairs, Science Po, and the associate tenant of 9BR Barristers Chambers in London. The third edition of his book, Genocide in International Law, right there up on the screen, was published in February 2025. Other recent publications include the International Legal Orders Color Line, which we just discussed. And I was kind of curious to hear more about We Charge Genocide and why you thought that was a solid document, and hear a little bit more about Lemkin. That was a question I wanted to ask when we ran out of time in the last session. And the Customary International Law of Human Rights, published by Oxford in 2021, and the published version of the course he delivered at the Hague Academy of International Law in January 2021, entitled Relationships Between International Law and Other Branches of Public International Law. He has also appeared as a counsel before the International Court of Justice and the Grand Chamber of the European Court of Human Rights in cases involving the Genocide Convention. Professor Schabas is an officer of the Order of Canada. As a Canadian, that's very meaningful to me, and a member of the Royal Irish Academy. In 2014, he served as the chairman of the UN Commission of Inquiry into the Gaza conflict. And I wanted to add, he's also a board member of the Zorian Institute, who is bringing us this session here again. And my students actually read Professor Schabas's work from the Oxford Guide of Genocide Studies. It's a comparative genocide class for a history capstone. And I returned to my Zorian notes from when I took that seminar, and I wrote a lot of notes. I was going through it again, and just so it's pages after pages after pages, because as we saw in the last session, Professor Schabas is fountain of legal and international law knowledge. Thank you.
Well, thanks again for giving me the floor, and thanks to the organizers of the whole week, and to Zorian, of course, for sponsoring my participation, and for their support for this as well. It's not exactly, when I wrote that biographical note, I guess I was asked for it some weeks ago. I had been promised by the publisher that the book was going to come out in February, but it actually, according to the website of Cambridge University Press, it will be published on Thursday of this week. So I have not yet seen a hard copy. Apparently, the online version, the PDF version, can be purchased online already. And this is the cover, third edition. The first edition came out in 1999, and the second edition in 2009. And I've been working on this subject of genocide and international law for more than 30 years. I first was bitten by the bug in the early, about 1993, after visiting Rwanda, but this was prior to the genocide that took place in April of 1994. But I was part of a fact-finding mission that used the term, and we were called up on it as to whether we really knew what we were talking about. And I didn't feel comfortable, hadn't studied the subject very much, went to the university libraries. I then lived in Montreal, and we had 3 universities with law libraries to get the books out on genocide and international law. There were several books on genocide. We had a great scholar, historian of genocide, Frank Chalk. I mean, Frank is still there in Montreal, and I got to know Frank very well. But I couldn't find the law books on genocide because, well, to be quite frank, there were none. or at least there hadn't been any written since the 1950s. And so pretty much all of the scholarly writing on the subject of genocide was by historians and social scientists. And for some reason that I can't entirely explain, it had been left alone by the lawyers. There had been a few journal articles, but that was about the extent of it. So I had just finished my doctorate, and I was kind of looking for a new project, and I took this up and spent the next 4 or 5 years studying all of the available sources, which then consisted mainly of the debates that took place in 1947 and 1948 when the Genocide Convention was being negotiated, and then a handful of judgments, none of them by international courts. The main judgment on the subject of genocide, the main judgments were the two issued by the courts of Israel in the Eichmann case in 1961 and 62. And that was the extent of it. The book came out, as I say, at the end of 1999. And over the next decade, there was just a huge body of activity in the area of genocide. We had a landmark. It's a bit of a cliche to call a judgment a landmark, but this is no cliche to say that the judgment of the International Court of Justice in the case of Bosnia versus Serbia of 2007 was a landmark. And it got added to various judgments of the two temporary international criminal tribunals, the Rwanda Tribunal, the one that Judge Abu Osuji worked for, and the International Criminal Tribunal for the former Yugoslavia. Several other books came out on the Genocide Convention. Scores and scores of journal articles were published. So by 2009, when the second edition came out, there was actually a very significant body of material, and I took that into account in doing a second edition. And I think I probably assumed that that was the end of it. And certainly when the International Court of Justice in 2015 issued its second major judgment on the subject of genocide in the case of Croatia versus Serbia, it seemed to me we'd kind of exhausted the subject, the legal. We had judgments, we had big questions that had been addressed. But most of all, we didn't really have a tribunal anymore that was going to be prosecuting genocide. It's true that the International Criminal Court can do it, but it really only has one case, and that case barely exists, where genocide is charged. It's never had a trial of genocide. And the International Court of Justice had basically shut the door on the applicants in those two cases. When the judgment in the Croatia case was issued in 2015, my reaction was, well, this is the International Court of Justice saying, don't bother coming back to us. This is it. We're not interested in having, this is not the place for genocide cases. And yet, and I was wrong on that, and I recognized that in 2015, because in the last 5 years, roughly, the subject has just become a huge subject. And we now have, and this is, let me move on to my next slide. We now have 5 pending cases at the International Court of Justice based on the Genocide Convention. The International Court of Justice is the world court. So this is not a criminal court. It's not a court that prosecutes people. It's a court that, in a sense, prosecutes states. It's a court with the authority to convict a state for perpetrating genocide, although it has never done this. It has had 19 cases based on the Genocide Convention since the Genocide Convention was adopted in 1948. It had one in the early 1970s between India and Pakistan that went nowhere and was dropped when the two sides agreed to make peace. It had the 2 cases I've referred to relating to the wars in the former Yugoslavia, one filed by Bosnia, the other filed by Croatia, and those led to very substantial judgments that clarified a lot of questions, legal interpretation about genocide, but that dismissed the charges and made it very clear that the bar was very high before the International Court of Justice was going to find that any state had committed genocide. And then we had a collection of cases, 10 of them, filed by Yugoslavia against NATO countries back in 1999. And those were all thrown out essentially on technicalities, as was a case filed by Uganda against Rwanda in 2006. So 19 cases altogether, including the 5 pending cases of the Genocide Convention. But what you may not appreciate entirely is how significant that is in terms of the cases that the International Court of Justice has considered. Because in its entire history, this court, which began operations in 1946, hasn't had 200 cases. It's about case number 194, I think, now. And so that means that 1 of every 10 cases that's been filed before the International Court of Justice has been about genocide. And as I say, until 2015, I think the message was, don't come back here, except that that's what states have done. So we have now 5 pending cases. We have the case filed by Gambia against Myanmar at the end of 2019. And that's an important case because all of the other cases of genocide were cases where a state that considered itself to be a wronged state, an injured state, a state that had a direct interest in the case, had filed the case, whether it was Yugoslavia against the NATO countries, whether it was Pakistan against India, whether it was Croatia or Bosnia against Serbia. These were states that were directly involved, and they were using the court to settle a dispute between them and the states they were suing. But Gambia doesn't really have a dispute with Myanmar. Gambia is acting as a kind of a global citizen, saying that Myanmar is committing genocide and the court should rule on this, and someone has to step up to the plate, to use an American metaphor, and Gambia did it. It had a lot of support doing it. It had the support of the Organization of the Islamic Conference. It didn't have the money to pay the lawyers who took the case for them, but that money was raised from other Islamic states that were sympathetic to the cause. So actually, this case is a lot of states involved at the International Court of Justice, not just the 2, Gambia and Myanmar. And as I say, an extraordinary and really unprecedented development, a state taking the case where it has no direct interest in the case, but is doing so as a noble global citizen. The second case that's filed 2 years later, Ukraine versus Russia. This is a bit anomalous as a case, because Ukraine is not charging Russia with committing genocide. Ukraine is using the case, or was using the case, to litigate Russia's aggression against Ukraine. It couldn't do this directly. It couldn't sue Russia for committing the crime of aggression, for example, because neither Ukraine nor Russia, nor for that matter, neither Gambia nor Myanmar, have accepted the general jurisdiction of the International Court of Justice. But they have, all of them, as parties to the Genocide Convention, accepted that a case can be brought to the International Court of Justice based on a violation of the Genocide Convention. So the clever little trick of Ukraine, it seemed brilliant at the time, was to sue Russia, saying Russia is using a fake allegation of genocide as a pretext to commit aggression. And Ukraine was initially successful. It got a provisional measures order, but later it stumbled in the case. And in a judgment of just a little over a year ago, the court threw out that part of the case of Ukraine and instead said that Ukraine could continue to fight the case, but only to the extent that it has an interest in proving that Russia made a false allegation of genocide. And Russia has now done, and this is only a few months old, and it's not something that's public, and I'm not in a position I'm not in a position to know exactly what Russia has done, other than to say that Russia has made what we call a counterclaim. This happens in some cases Russia goes back to Ukraine and says, well, you say we violated the Genocide Convention. We say you violated it. And my suspicion is that Russia is saying, you say we made a fake claim of genocide. Well, you made a fake claim that we've committed genocide. And so that case is, that's where it is right now. It's moving forward slowly towards a hearing. And I guess one of the big question marks that hangs over the case is whether Ukraine and Russia, as part of a peace agreement, which they may reach at some point, whether that peace agreement will include dropping the case altogether. This is hard to tell, but it seems possible in a way that it would be impossible for example, for Gambia to drop the case against Myanmar, because there's no question of a peace agreement between Gambia and Myanmar, nor it would seem with the third case, which is South Africa versus Israel. And that case was filed at the end of 2023, 3 months after the latest conflict in Gaza began. The case now, well, a little later, I'll tell you exactly the progress or in the question period of these, of where this case is at. Israel is now, has a deadline to do one of two things. The deadline is in July of this year, and Israel can either answer South Africa's submission. So South Africa has stated its case. It's filed volumes and volumes of materials in the court, none of which are public, by the way, but they've all been filed with the court. And so Israel can either respond to them in July of this year, or, and this is, I think, more likely, it will respond by saying they have objections based on what we call admissibility and jurisdiction. These are preliminary objections, and they may say, we don't think this case belongs in the court. There are flaws in South Africa's case. In other words, without confronting the merits of South Africa's case, but instead dealing with procedural type issues. And so that's the next stage in that case. And then shortly after South Africa filed the case against Israel, Nicaragua filed a case against Germany that is also related to the conflict in Gaza. And Nicaragua is charging Germany with failing to prevent genocide committed by Israel, and with perhaps being an accomplice in genocide committed by Israel. So there are two facets to this. One, as I say, is failing to prevent it, and this is a doctrine developed by the International Court of Justice that states are required to, where they are in a position to do so, a position of influence with another state, they are to exercise that influence to prevent genocide. In other words, outside of their borders and on other states. And the court developed this doctrine in the case of Bosnia versus Serbia, and Nicaragua is now attempting to apply it to Germany. Plus, of course, it's arguing that Germany has also provided material assistance to Israel, and therefore, if Israel is committing genocide, which Nicaragua will have to prove, then Germany has contributed to that. And then finally, the fifth case, which was filed only a few weeks ago, Sudan versus the United Arab Emirates, because the United Arab Emirates, according to Sudan, has been supporting and funding the rebel group, which was trying to seize power in Sudan, and which, in the developments in only the last week or two, is on the retreat. And I think it's sometime the middle of next week, there will be a hearing. There will be a day of hearings at the International Court of Justice here on the Sudan's charge against the United Arab Emirates. So 5 cases, an unprecedented situation. And I don't want to overuse the word unprecedented, but the International Court of Justice, this is part of a bigger picture at the International Court of Justice, which now has an unprecedented, there's my favorite word again, level of activity with 24 cases before the court, and several other cases before the court are also dealing with treaties in the realm of human rights. 2 cases based on the Racial Discrimination Convention, one filed by Armenia against Azerbaijan and another by Azerbaijan against Armenia. A case filed by Canada and the Netherlands against Syria based on the United Nations Convention Against Torture, and a case that's pledged by Canada and several Western European states against Afghanistan based on the Convention on the Elimination of Discrimination Against Women. Well, the International Court of Justice has always had a few cases dealing with human rights matters, a few. Of its almost 200 cases, the vast majority have dealt with disputes about borders, disputes about immunities of diplomats, and similar matters. And now suddenly, and this is, I say, in the last 5 or 6 years, it has a raft of cases. About half of its caseload is dealing with human rights matters, not to mention 3 other advisory opinions. This is another type of activity of the International Court of Justice. Advisory opinions that are requested generally by the General Assembly of the United Nations. So that means you need a majority vote in the General Assembly of states wanting to see a political question, a question that they debate in the General Assembly, addressed through its legal dimension by the court. So extraordinary, I just say it may be a bad time for the world, but it's a good time to be a public international lawyer because there's just there's a lot going on. There's a lot to teach, and there's a lot to write about, and it keeps one busy. One final facet of all of these genocide cases in particular is the phenomenon of intervention. So we have, I think now, by latest count, 45 states, 45 out of 193 or a few more in the world. So about a fifth of the states in the world have intervened in these proceedings, some of them more than once. And this is also quite extraordinary. It's never happened before in the history of the International Court of Justice. Since 1946, there have been, I think, until this latest batch of interventions, about 4 interventions, maybe 5, and only one of them has ever been granted. And now there's just an enormous number of them. So, just in terms of genocide, the issue of genocide and the interpretation of the Genocide Convention, we have the 10 states that are parties to these cases, plus another 45 that have intervened. That's 55 governments that are wrestling with questions about genocide, about the interpretation of the Convention on Genocide and its application to a range of different issues, whether it's Gaza, Myanmar, Ukraine, and Sudan. And we're going to see, I think, in series, judgments of the courts. We've had what are called provisional measures orders. The first one was quite dramatic. This was the one that Gambia obtained in January of the year 2020 against Myanmar, and then one against Russia, and then 3 of them that South Africa has obtained against Israel. And they are all, I want to say, I don't want to take the luster off the skills of the lawyers who argued for them and who were successful in obtaining them, but the threshold for obtaining them at the International Court of Justice is relatively low, and many of them are not really very, very robust in terms of what they ordered. So in the case of the Gambia, the order was to the Gambia not to commit genocide and to respect the Genocide Convention, which of course the Gambia would, not to Gambia, but to Myanmar, to which Myanmar will answer saying, yes, we agree. We're parties to the convention. We agree we shouldn't commit genocide. We didn't commit it. So it's that kind of an order that you can get at the International Court of Justice. They do have a considerable political impact, nevertheless, whether it's the case of whether it's the impact against Myanmar politically, against Russia, in the case of Ukraine. And one feature of the case that the order that South Africa obtained against Israel was that in that the court was saying that there is a plausible, some of the arguments of South Africa charging that Israel is violating the Genocide Convention are plausible. And I must say, although I don't know that this is the case in the United States based on what I've been reading about what's going on in your universities, but where I teach in the UK and in France, it has made it more acceptable to debate questions relating to the relevance of the charge of genocide in Gaza. And to that extent, it's, I think, enhanced our freedom, our academic freedom, and our freedom of expression. Now, I have two other slides here just to tell you about where some of the other developments are on genocide. And then what I'm going to propose to do is to stop for maybe some preliminary questions rather than try and present everything in a 45-minute monologue. Stop, and if there are questions and discussions, and then after a few minutes, I can revert and sort of pick up and continue with some of my presentation. These next two slides are about other places where we are getting attempts at legal findings relating to genocide. So one of the features of the activities of the United Nations are these what are called UN fact-finding commissions. They are generally created by the Human Rights Council. The one that I was a member of in 2014 was created by the Human Rights Council. And there are three of them in recent years, I think three, I hope I'm not leaving anyone out, that have made findings about genocide. So these are not courts. Their evidentiary sources are often not public. They often rely a lot on information from human rights NGOs, which may or may not be reliable. And they are based on a standard of proof that we call reasonable grounds to believe, which is pretty much at the bottom of the spectrum. When we're talking about the International Court of Justice to make a finding of genocide, they have to be more like beyond a reasonable doubt. The court doesn't use that term. It uses other language, but in effect, it means you've got to be sure that they're committing genocide. And if you have a doubt, you're going to reject the charge. But this is not the case in the fact-finding commission. So we have a commission of inquiry dealing with the Yazidi in Syria that made reached conclusions about genocide being committed. We have the one dealing with the Rohingya in Myanmar that issued reports on the subject, again, 2018, 2019. And then most recently, just earlier this month, the Commission of Inquiry of the Human Rights Council dealing with the Gaza conflict, which had issued a number of reports since it was created, more than well over a year ago, but had not used the term genocide, but has done so now in the report that it issued earlier in the month of March. And then we have the genocide prosecutions at domestic courts. And I know that earlier today, well, we've had a number of references to the Eichmann trial. We never can talk about genocide really without somehow going back to the Eichmann trial, which was a hugely important trial. Technically speaking, of course, many of you will know this, Eichmann was not tried for the crime of genocide. He was tried for the crime of crimes against the Jewish people. But all this was a rewrite in the laws of Israel of the Genocide Convention so that it would apply retroactively to the adoption of the convention. In other words, so that it would apply to the crimes committed during the Second World War. And it was really a law that was developed to prosecute collaborators. And the speaker this morning referred to this, and there were several prosecutions of collaborators, but then the law was pulled out and used for Eichmann. And the Eichmann trial was, of course, the precedent for the universal jurisdiction prosecutions. And these are, again, they're kind of the twin of these cases we get at the International Court of Justice, where someone is being prosecuted or a state is being sued by a state that has no direct interest in the case, that has no link to the case, but is simply doing so because genocide is wrong. And so we get that. That was the Eichmann case. Obviously, there was a state that had an interest in the events, but many states today are prosecuting genocide. Argentina, France, Belgium, Sweden. There have been many, Finland, there have been many prosecutions, Canada, based on what we call universal jurisdiction. And of course, the greatest number of genocide prosecutions by far, and I doubt that this will ever be equaled, is by Rwanda itself. Some of them under the ordinary criminal law of Rwanda, and the vast majority of them using these more informal courts called the Gacaca courts, but nevertheless judging people for the crime of genocide. Well, we can come and talk about the definition in a sort of a next phase of this, but if there are questions, I'm very happy to stop now and answer and speak to some of the points I've already addressed.
Okay, we do have some questions in the room. Thank you for the first part of your presentation lecture here. We'll go with Hava and then Saba.
I guess I have two questions. I'll start with the first one. Can you elaborate more on the relationship or the interplay between politics and law? A lot of time the sense is that we are witnessing political dramas. There are all sorts of factors that operate in that drama, but it has very little to do with legal inquiry, that we're actually doing politics rather than doing law. I don't know if that's fair judgment, but that's how it's, that's at least one my concern. The other one has to do more with how we use, and that's the slide that you have on the screen right now. Have we gotten to use the word genocide too loosely? Are we using it too cavalierly? Everything becomes a genocide, even though there may be other ways of describing atrocities or crimes or and so forth. So how does the word function today in international conversation?
Okay, very good. You've given me two questions that probably will take me to the end of the presentation today to answer them adequately. Politics and law. We are in an area where politics and law collide or interact, and there's no escaping this. I don't think it's. Well, first of all, when we're talking about the crime of genocide, we're talking about a crime that is quintessentially an act of a state or a state-like body, and that means we're in the realm of politics anyway because it's a political act. It's a crime that's related to some sort of political act of a state or of an entity that is behaving like a state. We've had debates, but these are more. This is just these are little sophomoric exercises really for law students. I think about individuals. Can an individual commit genocide in a certain circumstance? And I don't propose to get into that kind of a question. I don't think it's really very interesting or important because really the reality of genocide is that it's created by the Nazi regime, the German Empire, the Ottoman Empire, the Hutu regime, and so on. The other thing is that the reaction to genocide, and I gave the examples, I mentioned these 40 or 50, more than 50 states that are now directly engaged in a legal sense, not just with a statement by the foreign ministry, but with filings at the International Court of Justice. They are legally bound up in the interpretation of genocide, but they're doing politics. They're states. They're doing politics. And they are, by the way, also, and we see this in their statements, they make statements, public statements when they do their interventions, where they say, we're intervening to support. So some of them say, we're intervening to support Ukraine. More than 30 of them did that. We have a group, we're intervening to support South Africa. We're intervening to support the Gambia against Myanmar. If you read the statute of the International Court of Justice that talks about intervention, there's no possibility to intervene to support anybody. You can only intervene under Article 62 of the statute if you're there because you have an interest of a legal nature yourself. Or alternatively, you can intervene if you're a party to the convention in dispute and you therefore have a legal interest in the interpretation of the treaty. And that's the basis for most of the intervention in the interventions in these genocide cases. My point here is that the statute of the International Court of Justice isn't really, it's not like in a domestic setting where someone can join a court case to help someone else. And that's possible in domestic law under various, under certain rules, it's limited, but not at the International Court of Justice. But states say that. They say we're intervening to support them. Something else that we see in this strange hybrid atmosphere of politics and law is you have states that have taken positions about genocide in cases where it's politically useful to them. I mean, the United States is a good example. The United States said that it declared that China was committing genocide against the Uyghur. Okay, so China, no doubt, is doing some unpleasant things to the Uyghur, according to the various reports. But it's a stretch to claim that that's genocide. If the United States wants to stretch the definition, it can try. But the point is, it only wants to stretch them when it's dealing with the Uyghur. It doesn't want to stretch the definition of genocide when we're dealing with Gaza, for example. Quite the contrary. So we're seeing some of that. We had in the interventions in the Myanmar case back in late 2023, 6 Western states, Canada, the United Kingdom, France, Germany, Denmark, and the Netherlands, prepared a lengthy analysis of genocide, of the Genocide Convention, where they argued for the court, the International Court of Justice, in the case of the Gambia versus Myanmar, to adopt a more flexible approach to proof of genocide, and in particular, proof of the intent to commit genocide. Well, they developed their arguments. They explained that it should be easier to prove genocide, for example, that evidence of displacement within a territory, so not expulsion, not deportation, but displacement, should be taken into account as evidence of genocidal intent. And they said, where you have a lot of casualties who are children, that this also should be a strong factor in reaching a conclusion that genocidal intent is present. And they said, more generally, you've got to make it easier to prove genocidal intent. So they take that view about the situation in Myanmar, but I don't think those 6 states take the same view when it comes to Gaza and Palestine, because the arguments that they developed are arguments that favor South Africa in its case against Israel. And so you're seeing these strange, contradictions as well that arise in the positions of states. But your statement there, well, genocide, people are using it to describe everything. I described it, I mentioned at the beginning of my talk how I became engaged in this subject and how I discovered that in the 1990s, that the international legal dimension of the crime of genocide had not really attracted much attention from international lawyers. And it was really the domain of people in the social sciences and historians. And I got to know many of these people. I was active in the Association of Genocide Scholars. I was even the president of it for a few years, even though I was pretty lonely as an international lawyer in the organization. One of the things that I found when I encountered that community, that constituency, was people would express dissatisfaction with the definition of genocide in the convention. And they would say, well, my definition of genocide is this. And their definition of genocide generally enabled them to fit a particular reality, a particular case that they were excited about within the definition, because they felt that maybe the convention definition didn't fit. There's been a lot of that. And as I say, there's been a lot of political manipulation of the definition by states. I mean, we have states that will adopt resolutions condemning China for genocide against the Uyghur, but they won't adopt a resolution condemning Turkey for the genocide of the Armenians. And in practice, there's the only comparison between those two is that there are, a million more deaths of Armenians than there are of Uyghur. And yet the parliaments are kind of indifferent to it. So as I say, this is a topic on which I could say a lot more. I'm going to come back to Article 2 in a minute. So maybe I should take the second question and then I'll return to my slides.
Quickly, I know there are other people who want to ask a question, but that question is very important, and that's the reason why perhaps it is important to have a court of law answer the question as to whether or not genocide happened. Because the terminology can get politicized by states, can get politicized in the street. And once that kind of, there is a slur or defamation attaches, it is difficult to shake it unless we have a court of law that makes that legal determination that what happened, genocide or not. And it's for that reason that I do believe, for instance, that a case in South Africa was a legitimate case that needs to be, we need an answer to. And then, so that exit, they'll say the court has a standard of proof. On a walk in the park. And at the ICC, for instance, where I worked as a judge, judges do acquit people that the prosecutor brought proceedings against. Because at the end of it, the judges would have studied the evidence and come to the conclusion as to whether the facts occurred or not. So it is important to separate that politics from law in that way, by having courts of law make that legal determination. Thank you.
Sandra, you're next.
I have a question. Well, it's along the lines of what's been discussed so far. But I am, because of what I do, I'm also a fiction writer, I'm a genocide scholar. And living in these worlds means that I see how the word genocide is being used differently. So here is my problem. As a legal scholar, I find it difficult to just use the word genocide. I'm speaking very specifically about what you mentioned, Israel and Palestine, because it's very different here. We don't seem to have the same freedom to talk about it. So when as a legal scholar, I'm careful about using the word, but when I go into circles of writers, they want to have an authority over it. So what we're seeing here is a bunch of non-lay persons. That's the only way I can describe it. You have the politicians who decide, as you said, willy-nilly when something is a genocide because it suits their political objectives. We spoke about the Uyghurs and the Uyghur genocide that was declared as such by the United States in January 2021. And now if we look at, for instance, the writers right now, when I was invited to several conferences and I tell them, let's not use the word genocide because the UN hasn't declared it a genocide yet. We're talking about, again, Palestine and Gaza, Palestine and Israel. They, as writers, and I've seen many manifestos across the world, including from the country I'm from, which is Mauritius, the writers are adamant about using the word genocide. They claim ownership to it. So we have non-lay persons from everywhere. We've got the legal scholars who know their requirements. We know that there are writers who feel that they're non-lay persons. They have to make a declaration about it. And we have the politicians who have their say. I only have these three groups because these are the three groups I know about. There are probably many more. So my question is now, it's one of the few cases where all of these different non-lay person groups are claiming authority over that word. how do you, as a legal scholar, an international lawyer, look at this schism, these schisms that exist among all these groups?
I'm not, I resist the idea that the only people who can make a determination or can make can reach a conclusion about genocide are lawyers. First of all, lawyers don't agree any more than anyone else does. As you all know, you can find lawyers to say practically anything. And with judges, we can have a variety of opinion from judges as well. And it would be a rare situation where you could have an international court, like the International Court of Justice, with 15 judges, where you would get anything resembling unanimity on an issue like genocide. So it's not as if there's an absolute truth that we're going to get somewhere. There have been some movements. There's even a proposed piece of legislation in the United Kingdom to require that before Parliament makes a declaration of genocide, that the matter be addressed by a judge, that there be some sort of a hearing. I don't know practically how that would work. You would need hearings. It could go on for, a huge length of time. And I don't know how practical that is, but it's a suggestion that's out there. The United States Department of State claim that they have a very rigorous procedure for making their determinations, but it's entirely opaque, as one who is surprised to hear that from the Department of State. And my impression is that not only is it entirely opaque, but that in practice, that it's something that ultimately comes down to somebody with the authority in the Department of State saying yes or no. And that's going to be entirely on, whose side are they on? Are they our friends or are they our enemies? But I also think writers, I think that social scientists, historians, they are all entitled to debate it and use the word the same way we use other legal words. And the thing that I think is helpful and useful is making it clear whether you're actually using the word in a legal context at all. And that's not always the case. When President Biden made a statement about genocide in Ukraine, I think in April of 2022, he had gone to some farming community in Iowa, which seems a strange place to start making statements about genocide. And he did a press scrum after, and someone said, "Is it genocide?" And Biden, gave it a little thought. I don't know that he was the most thoughtful person, but he sort of scratched his chin and said, "Well, it sure looks like this to me. Well, we'll have to see what the lawyers say," or something along those lines. And I don't have a problem with that, because at least they're acknowledging that it's just their own opinion, and they're going to let the lawyers, so to speak, say it. And there was a Russian guy who said almost exactly the same thing. There was a Russian leader who said almost exactly what Biden said, except of course in the other direction. So all of that, I mean, we can't make a rule that you can only use the term genocide if it's been proven in court, especially because one of the most important facets of this is being able to prevent genocide. And what are you going to say? Well, we all have to struggle now to prevent, but we're not allowed to say what we're preventing. I mean, we have to be able to, and the court's doctrine, this is the ICJ, the International Court of Justice, about the prevention of genocide, is that the obligation on states to prevent it arises when there's a serious risk of genocide. And that's a different thing as well. You don't have to prove that there's genocide, but you have to prove there's a serious risk of it. So there are different levels as well of what we have to prove. I just make one final point. I referred to the Commission of Inquiry of the United Nations using the term genocide of the Human Rights Council a few weeks ago. And of course, we have the special rapporteur, Francesca Albanese, who has made done reports about genocide. But we had the special advisor on the prevention of genocide who was astonishingly silent, not just on the subject of genocide, but generally about the conflict in Gaza for many, many months, where she appeared to think that Gaza was a minor conflict and she was much more interested in other parts of the world. So even within the United Nations, people say the UN said this or the UN said that, but I always tell my students, you have to be precise. You got to say what part of the UN, what it is, because sometimes the UN says more than one thing because it has different voices there.
Couple of comments, kind of complaint. First, here's the definition of genocide, and you don't have to be a lawyer to read that and apply it to the facts on the ground and say there's a genocide happening or not, at least a legal definition. So I agree with the professor, you don't have to be a lawyer to do this. And the politics of and genocide, I'll give you an example of the US. It has not recognized the genocide of Assyrians, Armenians, and Greeks in World War I. And it never will. Why? Because that is a card that it can only play once. And it doesn't want to play that card. It keeps it in its back pocket to use against Turkey whenever it wants something from Turkey. Now, my complaint. The activities of ISIS in Iraq and Syria in 2014 and 15 targeted Yazidis and Assyrians in equal measure. Yet, as an Assyrian, I see that the world has totally shut out the Assyrian narrative from their genocide and only focuses on Yazidis. And I'm baffled as to why that is. Because the genocide affected the Assyrian community just as much as the Yazidi community in both Syria and Iraq. So maybe somebody could shed some light on that. Why is that? Thank you.
Okay. Are there other questions? Because if not, I'll move on. Chair, I'm in your hands.
Just an observation. I've been looking at your definition, the definition that we have on the board. And notice how part of the problem may be the murkiness of the distinction between elements of genocide and war crimes or crimes against humanity. That, for example, the crime alleged against Putin about the transfer and confiscation of children, is actually a part of the definition of genocide. In other words, the litigation on this runs into a murky issue of whether you're really challenging genocide or whether it's really war crimes.
Well, of course, Putin is charged at the International Criminal Court with the transfer of children, not necessarily from one group to another, but simply with forced displacement of children. But the real problem in the Putin case is to prove that he did it with the intent to destroy the group, and that is almost invariably the hard part here. Establishing one of these 5 acts in the paragraphs in the definition of genocide has rarely been a great challenge. I mean, killing, if you don't have examples of killing members of the group, it's pretty hard to prove that you intended to destroy the group. I should add that the case law has added into the introductory paragraph before that word intent to destroy, those words, the word physically. And so the prevailing interpretation, this could change, but I think it's not likely to. The prevailing interpretation of the convention is that it's about the physical extermination of the group, and that's really the problem. And I'm going to move on to that a bit with a few other slides, and then I'll stop again for more questions. Proving the intent is very largely, I don't want to say in 50% of the cases, probably 80% of the cases, maybe more, the hard part in establishing the genocide is being committed. We call it the specific intent. It doesn't say that in the definition of genocide, and this is really technical criminal law in a way. I think most of you know that all crimes, and we don't say it explicitly for all crimes, but all crimes require intent. You can't commit a crime if you don't intend to commit the crime in some form or another, then it's not a crime and you'll be acquitted. Whatever it is, whether it's shoplifting, driving while intoxicated, or a murder. But we rarely prove the intent in any, the prosecutor doesn't stand up and say, here are the facts, here's what the guy did. And now I'm going to call some expert witnesses, some psychiatrists who are going to prove that he meant to do it, that he intended to do it. This doesn't happen in a court because we presume that people deem the consequences of their acts. And we, in effect, shift the burden onto a defendant to say, okay, maybe I did it, but I didn't mean to do it. I didn't intend to do it. And that's how, in ordinary courts for ordinary crimes, the debates about intent take place. We do have, but it's a small number of crimes, where we say that some specific intent is required. And I don't know what the laws are like in Arizona, and anyway, many of you aren't from Arizona, but most jurisdictions where you live, there'll be some crime about being in a car, in a vehicle, and being intoxicated. And it will be a crime because there'll be, related to that will be some presumption that we create that you meant to drive the car. And that's a kind of a specific intent, and the state would have to prove that somehow, unless, and this is what they generally do, they put in the law, say, the fact that you're drunk and that you're in a car with the keys proves that you intended to drive the car while drunk. So it's an example of requiring some additional element. So we require additional elements to prove this specific intent. Sometimes we get them in the form of direct evidence, speeches, social media. Think of the Wannsee Protocol of 1942. We have a document that the Nazis left behind. It's written down. I think the original is in Yad Vashem. That's where I've seen it. Is and I've been to the place in Berlin at Wannsee where they had the meeting, and so we know that that's direct evidence. We don't have to presume or infer genocidal intent to the Nazis because we have this direct evidence. Where we don't have a substantial amount of direct evidence, as I say, that could be in the form of speeches, statements on social media, and so on, and where we have to prove the genocidal intent based solely upon inferences drawn from the conduct. And people, I think non-specialists are probably more familiar with the term circumstantial evidence. You're basing someone's intent entirely on circumstantial evidence. And when you try and prove a criminal intent based on circumstantial evidence, the real test is not being able to conclude that they had that criminal intent, but being able to exclude any other reasonable possibility. And that's where most genocide cases stumble in an attempt to prove that. And so that's the difficulty that will confront these cases, for example, at the International Court of Justice. My final line on the slide says, failing proof of genocidal intent, the acts may still be international crimes. So if you're at the International Criminal Court, if you're charged with genocide and they can't prove that you had genocidal intent or that you committed the acts with genocidal intent, they can still convict you for the lesser, I'll put that in inverted commas, the lesser offense of crimes against humanity or of war crimes, depending on other circumstances. And that's generally possible in a place like the International Criminal Court. The same way, if you're charged with murder in a domestic court and where they can't prove that you had the intent to commit murder, they're going to convict you of assault and battery or some similar offense. The problem at the International Court of Justice is that the jurisdiction is based on the Genocide Convention. And so if you can't prove genocide, then you've got nothing. Then the case gets thrown out. And that's the source of great frustration to victims, but that's just the reality of how the International Court of Justice works. I wanted to say a word or two about historic genocide, because when we were debating a few minutes ago where to have these debates, some of these debates about genocide are never going to get to court. The historic, it's very hard to get a debate about a historic genocide into court. For the three great genocides, which I've listed here on the screen, of the first half of the 20th century, I think we've now reached the point where there really is nobody left alive who could be prosecuted. There may still be a couple of very elderly Nazis who are not, don't suffer from too severe dementia, but I don't know. I think we're pretty much, we've reached, because of human longevity, we've reached the end. So how are those cases to be adjudicated? There are other issues that arise. Reparations may arise, and we often get cases relating to the historic genocides as well, that concern denial and prosecuting people for denial. And I wanted, this is an element of it to bear in mind, and in citing it, I don't want anybody to think that I'm endorsing this statement, but this is where legal thinking is at these days. About 10 years ago, the European Court of Human Rights dealt with a case of someone who denied the Armenian genocide in Switzerland. And so he was prosecuted under Swiss law for denying genocide, and he challenged it basically under the freedom of expression provisions of the European Convention on Human Rights. So he was successful. And amongst the statements of the court is this paragraph 250, where they talk about the lapse of time. In the present case, the lapse of time between the applicant's statements, this is a genocide denier, and the tragic events to which he was referring was considerably longer, about 90 years. And at the time he made the statements, there were surely very few, if any, survivors of these events. While in their submissions, some of the third-party interveners emphasized that this was still a live issue for many Armenians, especially those in the diaspora, the time element cannot be disregarded. Whereas events of relatively recent vintage may be so traumatic as to warrant, for a period of time, an enhanced degree of regulation of statements relating to them, the need for such regulation is bound to recede with the passage of time. And I mean, it's a very controversial statement. We can ask ourselves, will 10 years from now it be more acceptable to deny the Holocaust than it is? And I know that this is not, in the United States, you have a more absolute approach to freedom of expression, at least according to the First Amendment jurisprudence of the US Supreme Court, although recent developments, one wonders whether you have any freedom of expression at all in the United States, based on what we read abroad. But in Europe, most European countries have legislation about denial of genocide, making it an offense. And yet here the court is saying over time, you'll be able to say things 20 years from now that you can't say today. Here's my little photo gallery of Raphael Lemkin, the famous man who invented the word. And there I am in the cemetery in Queens, putting a little stone on his grave. That's where he's buried. And I mentioned, I should just come back to this point, because I did mention Lemkin earlier, before we had the break. And I spoke about his opposition to the We Charge Genocide report that was prepared by the African Americans and submitted to the UN in 1951. They were talking about lynching in the report. I think the report, is my own view, is that it's a very fine report, but that, it probably doesn't entirely fit with the definition of genocide. it's probably taking a very generous approach to it. Again, weighing it all up, I look back on it and say, the report is a good one. And the facts that were documented there were very, very compelling. And so I think Lemkin was being a bit pedantic, especially because when he objected to the African Americans complaining about genocide, he said, "You want to see genocide? Look at what's happening in Lithuania." And this is just part of the phenomenon we've been discussing for the last half hour or more about the politicization of the term genocide. Well, I have a series of slides here. I'll make these available to you, but I'm not going to be able to explain them all now about how the notion of genocide arose in a political sense within the United Nations, driven by Lemkin himself, and as a reaction to shortcomings in the Nuremberg trial. Because Lemkin's proposal for genocide, which he made in the first session of the General Assembly, and you can see here on the slide, he was able to convince Cuba, India, and Panama to propose the resolution, not the United States, France, and the United Kingdom, but 3 countries of the South, and he was able to convince them to propose the resolution. And what he was upset about was the fact that in the Nuremberg trial, the judges had refused to convict the Nazis for offenses, for anti-Semitic crimes committed before the outbreak of the war. And they insisted that they weren't prosecuting genocide. They weren't using the label genocide. They were using the label crimes against humanity. And the idea was crimes against humanity could only be committed in association with an aggressive war. And that the reason for that, and I have a slide that expresses this, this is the American delegate, Robert Jackson, then a justice of the Supreme Court, for where the legal framework of the Nuremberg trial was developed. And this is Jackson. He says, the reason why we can't have a broad notion of crimes against humanity is that we have regrettable circumstances in our own country in which minorities are unfairly treated. And we think it's justifiable that we interfere or attempt to bring justice to individuals or to states only because the concentration camps were part of an unjust or illegal war. And he says at the end, there's no other basis on which we're justified in reaching the atrocities which were committed inside Germany, under German law, or even in violation of German law by authorities of the German state. And that resonates with me. My ancestors were German Jews. They were in Germany during the 1930s. Most of them fled after the Kristallnacht, or at the time of the Kristallnacht in 1938. But they got a pass on this. And that's what Lemkin objected to. And that's why Lemkin insisted on a new crime, repackaging crimes against humanity in a way, but calling it genocide and specifying that, and you can see it here in the resolution. This is Resolution 96, which was adopted in December of 1946. And there's no requirement that genocide be committed in association with an aggressive war. Well, I think I'm probably at the end of my tether.
You have perfect timing. Unfortunately, we won't have time for any questions because we do need to go downstairs for the keynote. But Professor Schabas, thank you very much for being so generous with your time and being on Zoom all afternoon here. I don't know what time it is in London, so I imagine you're up very late.
It's 12:30.
Well, we appreciate you even more. And
I'm going to sleep
thank
now.
you for returning to Lemkin and We Charge Genocide. I do appreciate that. And sharing your expertise on such an important, timely topic and conversation, because as it's been noted, right, the use of the term genocide and, hearing more from people sharing their expertise about the legal aspects and putting it in that context. So, thank you very much, and we will. And for people here in the room, and then we're gonna go downstairs to Cour 170. So that's just downstairs from here on the 4th floor for a keynote lecture, the Right to Peace Initiative by our keynote who spoke earlier today, Judge Chili Ibo Asuji. And those on Zoom, it's going to be on Zoom as well, and
5 o'clock.
at 5 o'clock, which would be 1 a.m. Professor Schabas time. So thank you, and we hope to see you downstairs and back on Zoom.